Welcome everyone and good afternoon. Welcome to Landlord-Tenant Issues Amid COVID-19, a Tenant's Perspective. My name is Elizabeth Dryden. I'm a partner in the Real Estate Department of Irvin Cohen and Jessup in Beverly Hills. I'm also the co-chair of the Real Estate section of the Beverly Hills Bar Association. Now, as many of you know, landlord-tenant relationships can often be difficult. The landscape is fraught with missteps and pitfalls on both sides. Amid COVID-19 and the ever-changing legislative reaction to the pandemic, these have only increased. I'm delighted to have with us today Elena Popp, the Executive Director of the Eviction Defense Network, to discuss these common missteps and how to avoid them. Elena Popp has been a housing rights attorney since she was licensed in 1985. In addition to being the executive director of the Eviction Defense Network, she is a proud member of the Healthy LA Coalition, Housing Now, the Right to Counsel Coalition, and numerous other nonprofits. She firmly believes that housing is a human right and that people have to come before profits. Now, before we dive into our program, a few housekeeping issues. You will receive your MCLE panel shortly after the program ends. Please also complete the survey and let us know how we did. The survey, a link to the survey will be included with your MCLE certificate. Throughout the program, there'll be points for questions and answers. I'm going to be monitoring the Q&A box in the Zoom, so please post your questions there and I will pose them to Elena. Without much further ado, we can get started. All right, Elena, you want to take it away?
Yes, thank you. Thank you everyone for being with us. I think my introduction says a lot about my point of view, and I am not an unbiased person. We hoped to get a second presenter, someone from the plaintiff's bar in this context, the landlord bar, but apparently nobody wanted to do this. It wasn't even going to be a debate, just, a little bit of, these are the points of disagreements. But I think you're going to get that speaker later on. So I'm going to do the presentation the way I do it for tenants, with a little bit of understanding that some of you are probably going to be representing landlords, and some of you might want to represent tenants. And with that, I'm going to share my screen. And I was asked to do a very basic landlord-tenant presentation that includes current COVID provisions. But we've all been kind of relying so much on COVID. I don't want people to forget that there is an entire body of law that has not been erased. And so when you analyze the case, you really do have to analyze it holistically. So let's start with what is rent control. Rent control laws are laws that dictate when and how much the rent can go up, the reasons that a tenant can be evicted, and whether or not a landlord can take away an amenity, and if they can, then what are the tenant's remedies? In most of the jurisdictions, amenities can be taken away as long as the tenant is compensated. If a tenant thinks there is a violation, in almost every jurisdiction, there is a rent board or a housing department or somewhere that they can make a complaint. Rent increases and rent control ordinances are loosely based on the Consumer Price Index, which actually makes very little sense. The Consumer Price Index is the average change in the cost of certain consumer goods, including transportation, energy, and food, which really has very little to do with the cost of housing. Most laws peg the increases to the Price Index itself. Some are a fraction of the Consumer Price Index. Some are X amount plus the Consumer Price Index. Some are based on some sort of formula based on the Consumer Price Index. Each law is different. And in order to understand rent control, you also have to understand the concept of vacancy control. So in the 1970s, when the first laws were written, some of them were rent stabilization laws, like the Los Angeles Rent Stabilization Ordinance, and some of them were rent control laws, like the Santa Monica Rent Control Charter Amendment. A rent control law protects the rent on the unit. It doesn't matter who's living there, why they moved out, who moved in. A maximum allowable rent is set based on some formula at the start of, right after the passage of the ordinance, and then no matter who's living there, the rent stays the same. A rent stabilization law allows rent increases upon vacancy, with sometimes exceptions, but generally if a tenant moves out voluntarily or is evicted for cause, then the landlord can bring the rent to market. From the point of view of tenants and tenants advocates, vacancy control is bad. And it is bad because it provides a financial incentive for landlords to want to get rid of tenants so they can charge a higher rent. And it leads to harassment. And we have seen since May of 2016 an increase in harassment as market rents go up and landlords seek to persuade tenants to move out. Usually the process is, I'll give you some money if you move out. Tenant says no. I'll give you more money if you move out. Tenant says no. I'll give you more money if you move out. Tenant says no. You can't have your plants on the balcony anymore. 3-day notice to cure or quit, but I'll give you money if you move out. That pet that you've had for 10 years, can't have it anymore, violates your lease, but I'll give you money if you move out. And this stick and carrot process happens until, in most cases, the tenant gives up. And in some cases, the tenant gets connected to a tenant union or a community-based organization, and they organize and they get empowered and they don't. And then eventually they end up meeting me because the landlord finds some reason to evict them. And that is something that has been on the rise since May of 2016 when this current housing crisis started, and seriously on the rise since COVID, but I'll talk about that in a minute. So this illustrates the difference between rent stabilization and rent control. And again, the difference is whether or not a landlord can raise the rent to market when the tenant moves out. Elizabeth, can I ask you, do you, when you see my screen, do you see the entire presentation, or do you see you and me in the corner?
I see you and me in the corner, but I do see your entire screen.
I'm gonna kind of make us little then.
Okay. Or blocking your view.
Yeah.
Actually, that's the attendee settings, so everybody personally can adjust their screen size.
Oh, I see. Okay, great. So in 1995, a law called Costa-Hawkins was passed. It was a very pro-landlord law. It did a lot of things to restrict rent control and how rent control laws are can be passed. For instance, restricted local jurisdictions from passing any laws to protect any unit built after 1991. It prohibited vacancy control, and although vacancy control laws no longer had vacancy control, It dictates that when the last original occupant of a unit moves, the rent can go up to market, and various other restrictions. Advocates have been trying to get rid of Costa-Hawkins. In 2018, Proposition 10 failed. And this past November, Proposition 21 failed. Huge amounts of real estate and landlord money put into the campaign to defeat it. And in all honesty, I am an activist, so I will say this. We live in a state where the landlord lobby is feared. The local landlord associations are mom and pop groups, usually, predominantly. And they have some money and a lot of members. And what electeds fear is money and votes. The statewide organizations have fewer members with lots of money, the big Wall Street investment companies. And what the tenants' rights movement has is lots of votes, but a real difficulty getting people to think critically about a ballot initiative and not being able to reach enough people to teach them to follow the money and not vote against their own economic self-interest. So hence we have been defeated twice. The Ellis Act was passed in 1985. And what the Ellis Act was brought forth after elderly couple that wanted to get out of the rental housing market in Santa Monica was prohibited from doing so by a very strict Santa Monica law. And so the Ellis Act was passed the intention was to allow mom and pops to get out of the housing market. But the law doesn't say anything like that. And it is very, very broadly construed and has resulted in the loss of a huge number of units, 28,662 since between January 1st and March 25th, for example. As a result of vacancy decontrol, the cost of housing has gone up because there is nothing to stop it. I liken it to, landlords can ask whatever they want because people are willing to pay it, and people are willing to pay it because vacancy rates are low. It's a little bit akin to why a Borofsky doodle will net so much money. It nets a lot of money not because it's worth the paper it was written on, but because people are willing to pay that much money. At the same time, the economy hasn't grown as quickly, and particularly not wages, and hence housing instability. I've mentioned the current housing crisis. Started in May of 2016. Between May of 2016 and November 2016, rents for a single in Pico Union, where my office is located, went from an average of $800 for a single to $1,100, and by the following February, $1,300. That has sparked a housing rights movement. There are more tenants involved in tenant unions now than the history of the state. And those tenants are fighting for stronger laws. It's not the first time. In the 1970s, we had a similar housing crisis that led to a homeless crisis in the early 80s. And it resulted in rent control laws all over the state, locally in Los Angeles, West Hollywood, Santa Monica, and Beverly Hills. As a result of this current crisis, we have now ordinances in unincorporated LA County, Baldwin Park, Inglewood, and Culver City, and a just cause ordinance in Glendale. Right after we lost Prop 10, the very next day, the Alliance of Californians for Community Empowerment called for a movement to fight for statewide rent control. I was at home nursing my wounds and trying to figure out how not to be vindictive against anyone who did not walk their precincts, when I get this call to go at a demonstration at the offices of one of the biggest funders. That sparked a fight for a statewide bill. By March 15th of 2019, let me make sure I got my dates right. Yeah, by March 15th of 2019, we had a bill, AB 1482, and it was signed into law in September. Like all rent control laws, it defines what units are covered. This is a little cheat sheet that I like. It defines what units are covered. It has provisions for the types of reasons that tenants can be evicted, divided into fault evictions, tenant did something wrong, and no fault evictions. In the TPA, failure to pay rent, lease violations, nuisance, damage to the property, refusal to sign a lease extension with the same terms, criminal activity, subletting, refusal to let the landlord in, using the property for unlawful purposes. It makes it clear that managers whose employment is terminated can be evicted. And it also makes it clear that if a tenant gives a 30-day notice that they're leaving, they have to leave. That, for instance, is not in the LA ordinance. I've had many clients who gave notice, couldn't find a place, landlord tried to evict on that notice. You can't. It's not one of the 14 enumerated reasons in the LA law. And then there are no fault evictions, and there are 4 in the LA law. I mean, in the TPA, in the Tenant Protection Law: owner or family move-in, removal from the rental housing market to comply with a government order if the unit is a bootleg. And this 4th one, which ended up being a huge loophole, to do substantial remodeling. The definition is very loose. Right before the pandemic, we started getting a huge number of these 60-day notices to quit so I can do substantial renovation or substantial remodeling. And then the pandemic hit. And now under 3088, which I'll talk about in a minute, that loophole has been closed. Another loophole in this law is that tenants have to be there for a year before they are protected. So we're seeing tons and tons of cases where landlords are refusing to renew leases for tenants that exercise their rights under either local emergency tenant protections for COVID non-payment or under AB 3088. And you will note that I will not use the word moratorium in this presentation. There have been no moratoria. There's been a lot of confusion because of the use of that word. Tenants think the courts are closed. Tenant thinks that evictions can't be filed, and then they're surprised when they get a notice to vacate from the sheriff. So, there are emergency tenant protection measures, and so we are going to be arguing in those cases that that's retaliatory, that the only reason they are not renewing the lease is because the tenant exercised a right. Very weak relocation provisions. I think it's 2 months rent. And that's the basics of AB 1482 or the Tenant Protection Act. I'm going to cover briefly the LA City Ordinance. The LA City Ordinance protects all residential dwelling units, and it has a very broad definition. And if you read through it, it defines lots of, it lists out lots of stuff and the definition under the code. But it references a section of the state building code, I think, that basically says any structure or portion thereof that is either used or intended for use as a residence. And so, it includes a lean-to in the backyard. So broad definition. And then there are 10 exemptions. Like most rent stabilization laws, subsidized housing is exempted, public housing is exempted, student housing, cooperatives, board and care facilities, and anything like that. So those kinds of housing is exempted. Like most rent control ordinances, single family homes are exempted. Condominiums were not originally exempted, but Costa-Hawkins exempted from the rent restrictions any condominiums, but any condominium built before October of 78 still has the just cause and relocation protections. And if a condominium is occupied by the same tenant that was there before Costa-Hawkins was passed, that tenant is grandfathered in with full LARSO protections. The other big exemption is any unit built after October 1st, 1978. In the TPA, it's any unit that is less than 15 years old. Mm-hmm. and it's a rolling date so that we don't end up with this situation that we have in LA. 78 was a long time ago. And so, so we have a rolling date in the TPA. A little note on single family homes. Single family homes are exempted, but only if they're used as single family homes. Within the exemptions, there is an exemption for hotels, motels, boarding houses, and all transient facilities. And then within that exemption, there is an exception for boarding houses. And a boarding house is defined as a dwelling, single family, in which one or more room, or in which up to 5 rooms are rented to individuals. In my view,
Go ahead.
in my view, there is not a, there's not a, the larger state statute does not apply. If the tenant has been there more than 30 days, they are a protected rent-controlled tenant. There's a recent published decision that my firm actually defended the appeal after we won at trial that very clearly establishes that if you rent a room or more in a single family home, you are creating a rent-controlled tenancy. Is there a question that somebody wanted to ask?
Yeah, where do ADUs fall into this exemption?
So ADUs in the city of LA, ADUs aren't supposed to be rented. So ADUs in the city of LA are not covered, are bootlegs. So in the city of LA, ADUs are bootleg units. You cannot rent them. In the county ordinance, they specifically protected ADUs.
Mm.
And I think there's going to be movement in LA to allow property owners to rent ADUs. Any other question right now?
There's one that just talks about, you touched on harassment, so this is maybe going back a little bit.
No, it's forward. I'm going to talk a lot about harassment.
Okay, then we'll get to it. It's an interesting question, so we'll get to it.
My hair is grayer than it should be because of landlord harassment during.
Oh, sure.
So we have a whole section on harassment. So rent increases in LA theoretically are based on the consumer price index. There's some formula that takes it into account. I've never seen the formula. No matter what the consumer price index is, it can't be less than 3%, plus 1% of the landlord pays the gas and 1% if the landlord pays the electric. There are 14 reasons to evict a tenant. You can find those reasons if you Google City of Los Angeles rent control reasons to evict. There's a lovely 4-page bulletin that explains the kinds of notices and the eviction process. If the landlord wants to take away an amenity, meaning something that's not required by law, so not the toilet, not the water, not the plumbing, but the parking, the swimming pool, the washing machine, the recreation room, use of the garden, then the landlord must compensate the tenant by reducing the rent. But that generally doesn't cover it. You know, if you moved into the place because it had a swimming pool and a jacuzzi and you lose that, then you've lost more than just a reduction. If you live in a place that doesn't have parking, then you've lost, you know, I had a client who was walking 10 blocks because his parking was taken away. So the $50 reduction is not enough to compensate the tenant. There is movement afoot to change our law so that it prohibits reducing amenities if the purpose for the reduction is to harass the tenant or persuade them to move out. That's how the county law is written. Theoretically, the owner can't change the terms unilaterally. So if you have a pet, they can't take that right away, but they can reduce amenities. And for more information, this is the HCID website. There's a link for renters, there's a link for landlords, and tooling around will get you all of these bulletins that are very nicely written and a link to the ordinance itself. The county ordinance, my apologies, this for some reason I can't get this slide to animate. The county ordinance has 6 exemptions, including single-family homes, condominiums, and accessory dwelling units, and units built after February of 1995. Increases, again, a formula based on CPI, but no more than 8%, which is a very large amount. Just cause protection with 8 legal reasons to evict. And you cannot take away an amenity if it's intended to force the tenant out. More information, there is that link. And we will provide a link to the presentation. So when you analyze a case, it's important that you know where the tenant lives. This is the County of Los Angeles, inset in the state of California. The white areas are the unincorporated areas of the county. Note these little patches throughout. So you cannot rely on a tenant saying they live in X, because if they live in Culver City, maybe they live in LA and maybe they live in Culver City. And people will say Culver City when it's not really Culver City. So you really need to know where they live. You can figure that out on ZMIS. There's a website called ONET, but you can only use it if you assert that you are, helping a tenant. And you can also look at the property tax assessor. You can also ask a tenant, who do you pay your electricity to? DWP, City of LA. Edison, probably unincorporated county. So that is, there are 88 cities within the county. LA is red. The other 87 cities are in gray. And I think about 8 of them, or whatever the list was, have rent control laws. So what law protects you depends on where you live. It also depends on the age of your building, how many units are on the law, and a few other factors. Questions up to this point?
Well, we do have some questions about the overlapping laws, but the questions are focused more on, and how should we refer to them, Elena? Not the eviction moratorium, but the
emergency tenant protection measures. I'm going to do an entire presentation on that. It's coming.
Okay, great. That's what I figured. So we'll hold off on that.
Here it is. Here it is. This is the network of laws that protect tenants right now. So 3088 passed October 31st, expires 131. There's already discussion to extend it and hopefully make it stronger. So we are expecting a new law in January, applies to all tenants in California, provides some protections for homeowners and small landlords, protects against eviction for non-payment of rent and no-cause evictions, and the tenants must take very specific steps that I'm going to discuss right now to in order to avail themselves of those protections. If they take those steps, the rent is not canceled, but the case is taken out of eviction court.
Oh, Elena, really fast, to be very clear too, this is specifically relating to residential tenants, correct?
And it only applies to residential tenants, correct?
Thank you.
Local emergency tenant protection measures. In the County of Los Angeles, the county has a law. The City of LA has a law, and about 40 other local cities have laws. And those laws are, so the way that they're applied today is, if the law, if it's pertaining to non-payment of rent, and the law was in place on August 17th, then that law is not preempted by AB 3088. Any law that was passed that has to do with non-payment of rent that was passed after August 17th may be preempted by 3088. Any protections that are not based on non-payment of rent, there are no restrictions. So there can be changes. So right now, there is a county law that talks about, that protects tenants with regards to rent, and it also protects any tenant in a jurisdiction that did not have a law on August 17th. There is a separate protection against no fault, no cause, and some evictions having to do with unauthorized pets and guests, which I'm going to talk about in detail, and the noise that they might make. That applies to all tenants in the county now. But we'll get into that detail in a moment. Most of these laws provide a defense to eviction, whereas AB 3088 basically says you can't even get into eviction court if the tenant sent back the declaration and paid 25% of the rent for September through January. I will go into that in detail in a moment as well. So you have to look at the local law to figure out what applies. There is a chart that I will put in the chat, something called the Tenant Survival Guide, and there is a link to a chart that explains the laws. There's also a Center for Disease Control order that was issued on the 2nd of September, effective the 4th of September. It expires the 31st of December. It prohibits evictions for non-payment of rent, and it doesn't distinguish pre-COVID and COVID rent, and we have been able to get stays of execution from many judges and not from some, and we're about to file an appeal on one that was denied until the 31st of December. It also prohibits no cause and no fault evictions. There is already talk about extending that to March. And so, the numbers are going up, folks. 1 million cases in 6 days, death rate going up. We need to keep people at home. And so we have new state orders that say that in an enclosed place, you can't have more than 3 people from 3 unrelated households. That means that every trial we do, every court appearance that's not done remotely violates that provision, because there's a judge, a clerk, a bailiff, no room for anybody else. So we need to figure out what we're going to do about that. That just came out on Monday. Then you also want to look at local rent stabilization, the breach of warranty of habitability, anti-discrimination laws, anti-retaliation laws, rent gouging. We are in a crisis, in a state of emergency. And so you cannot raise the price of any good, including housing, more than 10%. And then reasonable accommodation laws. So you can't deny someone the right to put in a wheelchair ramp or to have a seeing eye dog or an emotional support animal, etc. And we always need to look at the lease. People always tell me, oh, but I moved in 20 years ago and I don't have it and I'm month to month. Well, every time you pay your rent, that lease is renewing. And so it could either help or it could hurt, and we need to look at it. The way I describe this to my clients and to the people that I represent, and I'm usually making these presentations to people that are at risk of losing their housing, is that there has never been so much housing instability in the history of the state. Nearly 1 million people have not paid their rent for some months from March to the present and are at risk of displacement for it. Landlord harassment is on the rise. And there is so much instability. At the same time, this patchwork of laws has actually staved off what we've been calling the eviction tsunami that we expected in April. Should have had 391,000 evictions in April. We got about 300. May, same. By June, it was 671. The average has been in the 300 range each month. The average last year per month, eviction filings in the county of Los Angeles, 3,381. So it's a decline of more than 89% because of this patchwork of laws. Initially, what was protecting us was the Judicial Council Rule 1, which was put in effect on April 6th, and we lost it on September 2nd. There was an announcement that it was going to be lifted in June, and we waged this major campaign that worked, and so it was delayed. The day after the announcement, there were 88 eviction filings in one day, which shows that that was really stopping eviction filings. It was not a moratorium. Evictions could be filed, but no summons would be issued. And most landlords used the brain cells that they were given and decided not to waste their time, energy, and money if they couldn't move the case forward. And so evictions were not filed. In AB 3088, there was, I call that the tourniquet. I'm an analogies. Is it an analogy? I'm an analogies girl. Patient lying on the ground, bleeding out, communities losing housing, people being displaced. The governor looks at it and says, oh my God, that looks really bad. Nurse, come and do something. And the nurse is the local jurisdictions. I give you local jurisdictions the power to do something to take care of this problem. The local jurisdictions come and they do this patchwork of laws. Nobody cancels rent. There's still a danger of bleeding out. And the Judicial Council says, let's put a tourniquet on that, and passes Rule 1. But they don't clean out the infection. We still have this mounting rent debt, which is causing a lot of instability for both landlords and tenants, and hasn't been grappled with. And then AB 3088 basically replaces Rule 1 with protections in the sense that cases are being taken out of eviction court, which is a good thing, but the rent debt is still there. The laws are confusing, and so a lot of people don't understand them. So this safety net actually looks more like this. We're going to catch a lot of people. Every time I give this presentation, I do a presentation 4 times a week, sometimes 5. And the people in the presentation are going to be caught in this net as long as they do what we tell them, follow our instructions, stay connected. But many people are going to fall through this net for these reasons. We're in a health crisis, an economic crisis, 491,000 households unable to pay rent, landlord harassment on the rise, illegal lockouts, 75% increase from before pre-COVID levels. The laws are confusing. They have shifting expiration dates. There's all this preemption questions. What exactly survived 3088, and there's not enough legal assistance.
Elena, really quickly, we have a question from the audience about what you said before about evictions still being able to be filed, but no summons going out. What does that mean? Does that mean they're just kind of stalled then? And
it's over. So that between April 6th of 2020 and September 2nd of 2020, you could file an eviction action, but a summons would not issue. So they were just stuck. They were just stalled. And so we saw a reduction in eviction filings from the 3,381 2019 average to, depending on how you count it, between 275 and 350 average per month.
And so then once that judicial rule was expired or lifted, then those summons went out for the ones that had been filed?
Yes, so those summonses went out, and those are the cases we're seeing now. Between September 30th and October 5th, there was an actual moratorium on filing non-payment evictions, and that was in 3088. That now has been lifted. The presiding judge gave us a holiday so that all answers weren't due until the 17th. And so now we're starting to see not a tsunami of evictions, because 3088 is causing a reduced number of evictions, but more like a tidal wave of evictions. It's not even as big as the big wave at the end of Point Break, the movie. So we are kind of staying on top of it. I've been sitting here, my phone has been buzzing, and it's people trying to get access to I need to file an answer. It's that kind of stuff. So things are going up from pre-October 5th numbers, but not at the 3,381 level. So how we assess a case. If you're assessing a case, first thing you need to look at is there a rent subsidy? And, people question my willingness to educate people that might end up representing landlords. My interest in doing this, or my willingness to do this, is based on 2 things. I go up a lot against a lot of people who think that landlord-tenant law is not difficult. And so it's like litigating against a pro per, right? Because the lawyer just doesn't know the law. I've got this guy right now. The city of LA has sent him a letter that my client in this boarding house situation with 2 boarders is a protected tenant, and he just isn't having it. He claims he's going to get the police to lock her out under the lodger statute. And it's lack of experience, lack of knowledge, etc. And there's also a whole bunch of guys who represent tenants that don't know what they're doing. And I want them to go back to representing landlords, because if you don't know what you're doing, I'd rather you be representing a landlord. So if you're going to represent tenants, it's important that you become part of the tenant advocacy community. We do trainings, we have listservs, we talk to each other, we share pleadings, and we want everybody to do a great job. We don't accept switch hitters, so you have to choose a side. And we're very dogmatic about that. And if you are going to represent landlords, it's important that you know the law and not think that this is not rocket science. So the first thing you want to know is there a rent subsidy? Section 8, tax credit building, owned by a nonprofit that has some sort of subsidy attached to it, public housing. If that is the case, whole other slew of laws apply that are in the Federal Registry, and the tenancy is governed by both the lease, which is usually very thick, and the regulatory agreement, which is the agreement between the housing authority and the landlord. Then, is there a local rent stabilization law? If there is your unit protected? If it is not, is it protected by the Tenant Protection Act, which protects anything more than 15 years old, except single-family homes and condos, unless those single-family homes and condos are corporate-owned. One of the main proponents of the law organizes tenants in single-family homes and condos that were bought by Wall Street in the 2008 mortgage crisis, and so it was an important point for them, so they stayed at the bargaining table until they got that. Duplexes are exempt if the owner lives in the second unit. Then you need to look at whether emergency laws apply, 3088, local law, CDC order, or the CARES Act, which only applies to subsidized tenants. Is there a rental agreement? And then other laws, discrimination, retaliation, technical defenses. We are going to kick ass on every case that has been filed post-COVID. People are just not reading the law and just going forward willy-nilly, and we're going to have tons of technical defenses. And so for my lay people, I flash these 3 and then invite them to keep coming back so that I can teach them the law just in time for them to then have to relearn it again in January when it all changes. So this is 3088. For any rent between March and August that was not paid, the landlord must serve a 15-day notice to pay rent or quit that explains the law. They also have to serve a separate notice that explains the law, and a blank declaration that is in the code and can't be different from what's in the code. Tenant has 15 working days to send it back. If they do, can never be evicted for that rent. And according to this law, the landlord can start collection procedures on the rent that is in arrears starting March of 2021. If the tenant does not return it, then eviction file can be filed starting October 5th, but that eviction will remain sealed. For rents from September to January, every month, the landlord must send that 15-day notice with the declaration, the blank declaration, 15 days to return, exactly the same, except that the tenant must also pay 25% of the rents for September, October, November, December, and January. They don't have to pay it each month. They can pay it all by the 31st of January.
Elena, really quickly, that slide was really helpful and I appreciate it. And I just wanted to make sure I heard you correctly. So the landlord's responsibility is to send that 15-day notice every single month?
Yep. Every month the tenant does not pay.
Okay, every month the tenant does not pay. And
So
so
it's one for March through August, and then one for September, one for October, one for November, one for December, one for January.
and presumably then they would have to wait until whatever grace period would be under the lease and then send it. So it might be that these notices are going out later in the month then. Is that correct?
They're really not going out at all. We're not seeing a whole lot of them. We should be seeing hundreds.
Right. But assuming the landlords are doing what they're supposed to do and understand.
Yes, they need to wait until after the due date and then send them out.
Okay.
So another way of saying what I just said, but slightly different, is the following. And this is what we are telling people to do. Go ahead and submit, whether the landlord has sent you the notice and the declaration. If you want to get out of eviction court, submit a declaration, and on our website, you can get a copy of it with instructions. Every month before your due date, and no later than 7 days after your due date, send the one for September, October, November, and December. And if you haven't done it, do them all now. Why? Because a landlord that knows, that's gotten a declaration like that, is less likely to harass you for the rent. Why 7 days? Because there's this patchwork of 42 laws in here, and frankly, I can't keep track of which of them have 7-day deadlines, which have 15-day deadlines, which have 30-day deadlines. So let's just get everyone to do it on their due date and no later than 7 days, which is the shortest one.
Elena, very quickly, just because there's a lot of timing to everything that you're saying. What are you seeing is the effect of missing those due dates, both on the tenant side and on the landlord side? It seems like it'd be very easy to do that.
So if the landlord sends it and the tenant does not send it back, then the landlord can sue them in eviction court rather than have to sue them in small claims court. If the landlord doesn't send it, the landlord cannot sue the tenant in eviction court.
But then does that then restart every month? So then if the next month the landlord sends it and they didn't, so say they didn't pay in November, and the landlord didn't send a notice. December comes around, they don't pay. The landlord does send a notice. That means the landlord can evict them for failure to pay for December.
No, I think the landlord would have to send the notice for December and for November and December at the same time. But yes, I think that if the landlord sent a notice for any month and the tenant didn't send it back, I think the landlord could then evict for that month.
And there's like a catch up in all of this.
You know what? I didn't read that there's a catch up, but I can't imagine that there wouldn't be.
Okay.
We're advising that if a landlord sends the 15-day notice with a declaration after step 1 and 2 have been taken, that the tenant simply read it, compare it, make sure that it says the same thing. We've seen 2 where the landlord's like inserting payment plans in it. Can't do that. And I also had one where a tenant didn't like it the way it was written, so rewrote it. Can't rewrite it. It is what it is. It's either true or it isn't, and send it, or if it's not true, then don't send it, because then under penalty of perjury. And we are advising people to consult with us before they pay that 25%. Tenants in bootleg units, for instance, should not be paying the 25%. Because there's no rent due on a bootleg unit, and tenants with severe habitability problems are probably going to be better off in eviction court with a lawyer than in small claims court without one. This is what the declaration looks like. So you fill it out, you print one for each of these time periods. Currently unable to pay the rent because one or more of the following: loss of income, increased expenses, expenses due to health impact, childcare responsibilities, increased cost of childcare, or something else, and what money I'm getting isn't enough. The actual attestation is just signed under penalty of perjury. We actually decided to put the longer attestation because a lot of people are out of state right now, and if you're out of state, you have to have the longer attestation. So tenants have to choose whether they want to be in eviction court or not. And if you have an illegal unit or severe conditions and a lawyer willing to represent you, you might consider staying in eviction court. Tenants have to decide whether to pay the 25% as they go along. There is still some hope of rent forgiveness, and I can assure you there will not be rent reimbursements. and there's a lot of tenants who can't even pay the 25%. Stay Housed LA is a project of the LA County Department of Consumer and Business Affairs. Funds were given to the Right to Counsel Coalition, which includes all 10 legal services programs that represent low-income people in the county, and 13 community-based organizations. And we are providing counseling and full scope representation. Now, when do I have to start repaying the rent? My answer is when you get a job and can afford to pay it. That's when you start repaying. Well, what happens after February 1st? After February 1st, there will be a new law. When do I have to start paying the back rent? Well, that's a little more complicated. AB 3088 says March 1st of 2021 is when a landlord can start collecting. But most, both the county and the city are taking the position that the collection period starts 12 months after the local emergency ends. The city attorney wrote a very interesting position paper on why the local laws are not preempted by AB 3088. The analysis is basically, the only thing AB 3088 did is take the lawsuit out of eviction court. So if the tenant doesn't start paying, all the local protections are still intact. They just have to be litigated in eviction court after March 1st. And I think that is going to hold water. And then also keep in mind that there are 40 other laws that you'd have to look at if you're in a jurisdiction that has its own law. The County of LA law, again, protects all the white areas. It also protects any gray area that does not have its own law. And it also protects mobile home residents and commercial tenants in any gray area that does not have a law that protects those tenancies. It expires the 31st of January. It will be extended. It's been expiring month by month and extended month by month. This time they went out a couple of months, probably because of the holidays. And they're not meeting as often. The city of Los Angeles has no end date. Eric Garcetti said it ends when I say it ends. And 40 other laws with varying end dates. Again, if you're confused, ask your questions.
All right. Well, we do have some questions for you, Elena. I think you've actually done a pretty good job, though, of preempting some of these. Are we open for general questions now, Elena?
Yeah. Well, there's 2 more sections, but let's ask the questions and I'll say put it off or I'll answer it.
Okay, great. So one is about your experience with property management companies that turn over delinquent rent to aggressive collection companies, and that essentially try to squeeze tenants who are trying to defer their rent and run a bunch of credit reports to dent their credit rating and use that as a harassment tactic.
I personally haven't seen a lot of that, but whenever we get those kinds of consumer issues, we refer them to consumer attorneys. So I can't say I've seen a huge rash of those. I represent primarily extremely low-income people who are judgment-proof. And we have a very aggressive litigation style. In 98% of our cases, the rent is forgiven. So we don't, our clients don't tend to have that problem. I'm not saying it doesn't exist.
I understand. Another question is COVID related about landlords entering tenants' units and whether or not tenants can refuse to allow landlords to enter or their representatives to enter if they're not wearing protective, personal protective equipment like face masks and are not social distancing.
So I would say the answer is the following. In the city of LA, the original emergency order says that a tenant can refuse access, period. So in the city of LA, the tenant can refuse access. Outside of the city of LA, I think the tenant needs to be, I mean, I think even in the city of LA, you need to be reasonable. If there's a leak and they need to come in because there's a leak in the unit downstairs, you need to let them in. I think tenants who do not have special needs should insist on shoes outside, wearing booties. That's how, the virus is all over the streets. So it enters your house. Your pet walks on it, you touch your nose, and now you're infected. So everybody should be leaving their shoes outside. We have a disinfection room in my house that is adjacent to a bathroom. And before anybody enters the house, I mean, nobody is coming here, but if we go out and we come back, it's showers in your clothes, and we don't drag the ooglies in on our feet. Gloves, masks, no more than 2 people, because otherwise you're violating the 3-person rule. Don't allow people to touch things, and maintain 6 feet is what I think you can require. Next.
Sure. And then the other one, this question is, if the end of the emergency in Los Angeles is when the mayor declares it to be the end of the emergency, which is my understanding, and that's the kickoff essentially for the time period, for the ticking clock for when deferred rents or back paid rents are due. Is that correct?
I'm sorry. I say it again.
So that under the Los Angeles City Tenant Protection Ordinance, that the time period for the repayment of deferred rents starts when the mayor of Los Angeles declares that the city is no longer in a state of emergency.
That is the position of our city attorney.
Correct. Okay. That was it.
And I think what that means is that if you try to collect that rent, the tenant will have defenses. I don't know how it's going to shake out. We spent a month and a half, 66 lawyers trying to figure it out. And amongst our side, we had 66 opinions. So we're hoping to get a cleanup bill in January. And we're hoping that, I think what all sides of the bar need to realize is that if we can't figure it out, and if we can't settle these cases, you're going to be in litigation for centuries. Eviction cases were already 8 months backed up pre-COVID. If a tenant had a lawyer, it was taking 8 months to resolve a case. Post-COVID, there's going to be more representation because there are now funds to represent tenants. And so it's going to be really crazy. And so settlement is going to be very important, and both sides are going to have to be reasonable unless you want to be in litigation with each other for the next 10 years.
Sure. Well, and that kind of goes into our next question, which is about, the smaller landlord, the mom and pop landlords, who, they have their obligations too, of course. They have to pay their lenders, they have to pay their taxes, they have to pay utilities, things along those lines. And in particular with these smaller, older buildings, if they want to do improvements, but they're struggling with the market value of the rent, they're struggling with the fact they're not collecting rent. If you think they'll be available to them at some point, the ability to appeal or seek exemption from any of these ordinances.
Have not given that any thought. I think where we need to put our energy is in getting mortgage relief. So the CARES Act provides, if you're a good mortgage payer, for these payments to be put at the end of your loan, which is quite a benefit for.
But doesn't the CARES Act, and I will be honest, I'm not fully versed.
It's 30% of the loans in California. It's only federally insured loans.
That's what I was going to say. So a lot of these commercial buildings.
Yes, but we need something like that for the rest of the 70%.
Right.
The governor made some sort of deal with some of the major banks that's voluntary. I'm not sure how well that's working. We need to wrap our brains around this, because a population that has this much sort of expense and debt burden isn't going to be a population that restarts the economy, right? That's a population that doesn't go out to eat. We're already kind of getting used to not doing those things. And so then the restaurants don't open, nothing opens even after we have a vaccine, because people won't spend. So we have to do something about both the mortgage debt and the rent debt. if we hope to gain some normalcy.
Right, relief has to trickle upwards as well. It can't just be stopped at the landlord-tenant level. It needs to go up the chain of obligations, really, of financial obligations. But I just lost my window. Okay, so there's some questions about small claims here, Elena. Let me see. With small claims not having the financial cap for back rent, because a lot of the back rent is now small claims, will this potentially be the arena where the financial fight will happen starting March 1? Or do we expect, I think you were just saying, do you expect another law at the city or county level to change that or preempt it?
So small claims is where the battle is going to be fought. This is where the battle is going to be fought. And if there is a change in 3088, it's not going to eliminate small claims. The small claims limits have been lifted for this purpose. It will be interesting because tenants will be able to file cross complaints in those cases. There's a lot of people with lots of deferred maintenance issues. We're trying to figure out how to serve that population through small claims clinics so that they can not only just file an answer, but also file a cross complaint. And I think those cases will take forever to go forward. One of the projects that we proposed is something called Access LA that would basically recruit members of existing institutions like churches and schools and that have members and patients and congregants and teach them how to negotiate these agreements, prepare a standard 2-pager that cannot be modified. It's just how to get a payment plan done. Teach them how to play hardball and to explain to the landlord how backed up the courts are going to be so that we can settle out a lot of these cases before March 1st. So that's a project we're trying to get funded.
Well, and that actually segues very nicely into my next question for you, which is about mediation in the small claims court, small claims. And, for somebody who's a tenant advocate, what are the areas where you think where you could reach agreement with the landlord? Essentially, what would you consider being the BATNA on both sides? Question number one. And then number two, do you think it's important? I can't imagine how it wouldn't be, but for the mediators to understand what the city ordinances are, what the applicable ordinances are.
So yes, it would be important for them to understand the ordinances, but more important than that is understanding that, like, we have to have restrictions. I do not like mediation in housing cases because there is an inherent bias with everybody except landlord advocates, inherent bias in favor of moving out. And we have launched a housing movement that's all about staying in place. And so I am concerned that mediators will try to convince, and they do in UD court, they constantly try to convince tenants not to move out, and that is a problem.
All right. Going through questions. General question about understanding a good resource for understanding UD during COVID for business leases.
Sorry,
good.
At a loss. No, I
Not
don't.
Outside your realm.
Yeah, I have a couple of business clients, and it's been hard getting them out of their leases, frankly. I would go Nolo Press.
Nolo Press. All right. And then another question about the small claims court. Is that only for non-payment of rent, or can the other tenant landlord disputes be resolved there?
Well, any non-tenant dispute can be resolved there and now, right? You can you can file a small claims court now to resolve any landlord dispute.
Right, and I would say that in my experience, almost any dispute can be boiled down to a monetary issue as well.
Yeah. Oh, you mean injunctive relief? No, there's not going to be any mechanism for that. But anything that has a price on it can be resolved in small claims court now.
Sure. All right, so that is sort of the list of questions. Oh, and then one final question about small claims court, and the question is, have small claims jurisdictions been increased for these cases?
You mean the monetary value? Yes.
And do you know so you said under
it's whatever the rent is under AB 3888.
Okay. All right, everyone. Well, thank you so much for your time. Thank you, Elena. We really appreciate it. And everyone have a wonderful afternoon. And again, thank you for spending the time here with us at the Beverly Hills Bar Association.